I'm here to propose recommendations for considering production and marketing of a new line of cosmetic skincare products. I'm going to start off by telling you what a corporation is. A corporation is a fictitious legal entity that is created according to statutory requirements. A corporation can be created only pursuant to the laws of the state of incorporation. These laws, commonly referred to as corporation codes, which regulate the formation, operation, and dissolution of corporations. The state legislature may amend its corporate state statutes at any time. Such changes may require a corporation's article of incorporation to be amended. The Articles of Incorporation is the basic governing document of a corporation. It must be drafted and filed with and approved by the state before the corporation can be officially incorporated. The Articles of Incorporation may also include provisions concerning the period of duration, which may be perpetual, the purpose or purposes for which the corporation is organized, limitation or regulations of the powers of the corporation, regulation of the affairs of the corporation, and provisions that would otherwise be contained in the corporate bylaws. The reason for my emphasis on purpose is because the main purpose for Daggett Industries is to design and manufacture military-grade weapon systems for the United States government and its allies overseas. So with that being said, if you as the board of directors is considering production and marketing of a new line of cosmetic skincare products, you would need to amend your corporate bylaws. In addition to the Articles of Incorporation, corporations are governed by their bylaws. Bylaws are a detailed set of rules adopted by the board of directors after a corporation is incorporated that contains provisions for managing the business and the affairs of the corporation. The bylaws are much more detailed than are the Articles of Incorporation. The bylaws govern the internal management structure of a corporation. After the board of directors amend the bylaws, the board of directors must hold an organizational meeting, which is a meeting that must be held by the initial directors of a corporation after Articles of Incorporation are filed. Fiduciary duties. These are the duties of care and loyalty owed by directors and officers to their corporations and its shareholders. Duty of loyalty, which is a duty that directors and officers have not to act adversely to the interests of the corporation and to subordinate their personal interests to those of the corporations and its shareholders. Duty of care, which is a duty if corporate directors and officers to use care and diligence when acting on behalf of the corporation. To meet this duty of care, the directors and officers must discharge their duties in a good faith with the care that an ordinary prudent person in a like position would use under similar circumstances and in a manner that they reasonably believe to be in the best interest of the corporation. A director and officer who breaches the duty of care is personally liable to the corporation and its shareholders for any damages caused by the breach. Such breaches, which are normally caused by negligence, often involve a director's or officer's failure to keep adequately informed about corporate affairs. The doctrine of ultra vires played an important role in the development of corporate powers. Through largely obsolete in modern private corporations law, the doctrine remains in full force for the government entities. Ultra vires is Latin for beyond powers in the law of corporations. The doctrine in the law of corporations that hold that if a corporation enters into a contract that is beyond the scope of its corporate powers, the contract is illegal. The earliest legal view was that such acts were void. Under this approach, a corporation was formed only for limited purposes and could do only what it was authorized to do in its corporate charter. Modern corporation laws have sought to remove the possibility that ultra vires act may occur. Most importantly, multiple purposes clause and general clauses that permit corporations to engage in any lawful business are now included in the Articles of Incorporation. In addition, purposes clause can now be easily amended if the corporation seeks to do so business in new areas. Under modern corporate law, the purposes clause would either be so general as to allow this corporation to go into the skincare business, or this corporation would amend its purposes clause to reflect the new venture. And this is just a review of the ultra vires statute. A derivative action is a lawsuit brought by its corporation shareholders against the directors, management, and or other shareholders of the corporation. Reasons to a derivative action lawsuit. Directors and management are failing to exercise their authority for the benefit of the company and all of its shareholders, such as fraud, mismanagement, self-dealing, or dishonesty. Under the Model Business Corporation Act, the procedure of a derivative suit is as follows. There has been harm to the corporation, but the board of directors has not taken a measure against the wrongdoers. My recommendations would be go for it, only if you do it the legal way. If you, as the board of directors of Daggett Industries, amend your corporate bylaws and change the purpose of your business in the Articles of Incorporation, also keeping your loyalty to the corporation by making sure with your shareholders that this is within the best interest of this corporation, which is also within the duty of care and that you owe to your shareholders. Then you can discuss whether or not the shareholders may think this idea is ultra vires, and you can avoid a derivative action lawsuit against the board of directors because you would have avoided any harm to the corporation. And that's my project.